Good afternoon, everyone. Welcome to our quarterly Privacy Watch webinar. This is the last webinar for 2023 that we'll be doing here. This is focused on insights and predictions for 2024 and beyond. I'm Lauren Bernard. I'm the marketing director here at McMurray & Schuster. Before we dive in, I'm going to just cover a few housekeeping items. I know folks are still joining in. First off, I just want to let everybody know that this is being recorded, and the recorded webinar will be available on the website likely next week sometime. So if you have to hop off for any reason or want to share it with colleagues, it'll be available there. If you have any questions, I know we received a number of questions during the registration process, but if you have any questions during the course of the webinar, feel free to pop them into the question box. We'll see those, and we'll try to get to as many as we can as time allows. Lastly, we would not be a law firm if we didn't offer a legal disclaimer, so I'll try to get this right. The information that you're going to hear is for informational purposes only. It does not constitute legal advice. We know that every business's situation is unique, so when you have questions, it's best to turn to your counsel to answer those. I know some great attorneys that can help you with that if you are looking. And I guess we're ready to dive right in. So again, welcome again. Hopefully everybody is on. This is our last of the 2023 quarterly Privacy Watch webinars. I'm here with Nick Whisler, and Josh Stevens is joining us from his satellite office in Cincinnati. Welcome.
Thank you, Lauren.
And I just to introduce them, Josh and Nick are both partners in the firm. They lead the privacy practice here. Between the two of them, they have decades of experience working with federal, state, local privacy laws, and across a variety of industries. So with that, I think we're going to dive right in. And Josh, I'm going to start with you, if that's okay. You ready?
I'm ready.
Okay, so let's talk a little bit about federal privacy legislation. I know that there's a lot going on at the state level. We've been reading about it. You guys have been working with clients on it all year long. We'll get to those in a bit, but first, what are your thoughts about what's happening? What are you seeing right now at the federal level, and what can businesses expect to see in the coming year?
Yeah, at the federal level, let's start with Congress. And I like to think about it as it's almost like my car in a snowstorm. We see a lot of wheels spinning, but not a lot of traction. Over the past couple years, we have seen a number of bills proposed in both the House and the Senate to create a comprehensive national privacy framework, similar to what's happening at the state level that we'll talk about here in a little bit. But those bills haven't gotten a lot of traction. They just really haven't moved forward. And I don't necessarily see that changing anytime soon. The sticking points still seem to be over whether the bill should have a private right of action. The Democratic part of Congress tends to favor having a private right of action in the privacy bills. The Republican side tends to not favor that. My 2 cents is a private right of action is probably not the best in a privacy bill, because a lot of privacy requirements are kind of gray. They're not very black and white. And so having a private right of action creates a lot of risk. The other sticking point is around preemption. And so the Democratic side tends to favor a framework where the federal law sets a floor, and then states can set rules over and above that. And so it would not preempt state laws. Whereas the Republican side tends to favor having preemption and the federal framework being the framework, similar to what we saw happen in Europe with GDPR. And again, I think preemption makes a lot of sense in a privacy context, but that's my 2 cents. It's not going to get you very far. My worry is, if we don't have preemption, we end up with a situation that looks a lot like the TCPA, where you have a federal framework and then every state has its own nuances over and above that, which, while it's great for us, that's great for lawyers, it's not great for our clients. And so I think, that's the sticking point. The other thing I'll say, though, is 2024 is an election year. And we know that sometimes Congress tends to get really bogged down in election years because people are out on the campaign trail, they're distracted. And certainly with the current budget crisis that's happening, I think we just had a continuing resolution pass the House yesterday, kicking the can down to January and February. That's probably going to eat up a lot of resources as well. So I don't think we're likely to see come out of Congress comprehensive privacy legislation in 2024.
So is there anything that Congress can agree on, given that there's all these items up in the air right now? What can they agree on?
There does seem to be some bipartisan consensus around children and the need to protect children's privacy. So we saw in this Congress proposed the Kids Online Safety Act, which passed out of the Senate committee, but then stalled. That would have targeted social media companies and how they handle children's data. We also saw a bill that some people are referring to as COPPA 2.0, so the Children and Teens Online Privacy and Protection Act. It also made it out of a Senate committee and then stalled. But essentially what it would do is it would take existing law, so the existing Children's Online Privacy Protection Act, and take it from 13 and under to 16 and under, and would also set stricter rules around targeted advertising and algorithmic decision-making. So there does seem to be some bipartisan consensus that maybe something needs to happen around children's privacy.
Yeah, and to Josh's point earlier, the parties aren't that far off when it comes to the substance of these laws. They have some disagreements and preferences, but it's really about the enforcement mechanisms that Josh was talking about and the preemption issue. I mean, I think both parties very much agree on a lot of the core privacy principles. It's really more about how do you implement that in an actual legislative framework. And so that's kind of the interesting thing about the spinning of the wheels, as Josh said, that we're dealing with right now.
Always nice to hear that there's agreement at heart of the core issues. So aside from Congress, anything else that we can see at the federal level?
Yeah, regulators do their own thing too. And so the FTC this past year, past couple of years, we saw updates to the GLBA safeguards rule come out of the FTC. In fact, they just a month or so ago released another update around data breach reporting. So I think you're still going to continue to see the FTC trying to exercise what authority it has with regard to privacy. The other thing people need to remember with the FTC is they do have that broad Section 5 unfair and deceptive acts and practices authority. So they can interpret that. It's very flexible. And so they could use that to take some steps in the privacy realm. We've seen them go after data breach issues before data security issues, but I would expect to see additional enforcement. In fact, they, whether they get it or not, we'll see, but they've requested a 37% budget increase for this coming fiscal year, most of which going towards enhancing their privacy and consumer protection division. So I would expect to see more from them. And then the other one that's kind of popping that'll be really interesting is the CFPB with regard to FCRA, the Fair Credit Reporting Act. They have started a new rulemaking. It's in its early stages. The CFPB has a unique small business review process. And so the document they released for that process shows that this rulemaking that they're looking to do under FCRA would reshape the data broker industry. It would make businesses that today are not credit reporting, consumer reporting agencies or credit reporting agencies, as people call them, when you think of TransUnion, Experian, Equifax, those types of companies, but just run-of-the-mill data brokers could potentially be consumer reporting agencies depending on the types of activities they engage in. And that's going to be a big deal. If that rulemaking goes through, we're going to see a lot of change.
Gotcha. Let's pivot. Let's take a little turn toward the states now. I'm going to turn to you, Nick. So obviously starting with California and the CCPA, states are following suit. Colorado, Connecticut, Virginia. They've introduced their own privacy laws, and we've got this web now of 13 state laws now. What do you see? How do you see things shaping up?
Yeah, so 12 laws, 13 if you count Florida. Florida looks like a comprehensive privacy law. The reason it often doesn't get lumped in though is because its scope is more limited. It's really focused on big tech companies. And so it's generally not lumped in with the others. You mentioned the ones that are in existence today. Utah is another one. It actually goes into effect at the end of this year. So I know a lot of companies have already gotten in front of that one and added that to the list of states where consumers have privacy rights. In terms of substance, really what we're seeing is a lot of copycat legislation. So the laws seem to be largely coalescing around what we often refer to as the Colorado-Virginia model. Many others also refer to it as the Washington model because although Washington never actually passed legislation, it took a heavy hand to the drafting and almost passed it a few different years, and that served as the basis for what Virginia ultimately did. So you'll sometimes hear it referred to as that. But at the end of the day, the rights that are provided under those laws, the verbiage that they use, all borrows heavily from that model, which borrows heavily ultimately from GDPR over in Europe. There are some nuances though, right? And so companies need to be thinking about these, and certainly don't have time to get into all of them, but things that come top of mind would be Oregon has very specific privacy notice or policy requirements. So you have to disclose all of the legal entities that are covered by that privacy policy. You can't just say and affiliates, for example. You also have to disclose the specific third parties to whom you'd be disclosing personal information. That's a little bit different. Most of the other frameworks talk about disclosing the categories of third parties to whom you sell or share or otherwise disclose personal information. So that's a nuance. Other examples are Tennessee incorporated the NIST privacy framework by reference. So that is unique. Texas is actually a little bit broader in scope. Most of these laws have applicability thresholds that you have to hit based on, well, in California it can be revenue. In most states it's based on the number of individuals whose personal information you have, or if you make a majority of your revenue by selling information. Texas actually applies if you sell information at all, even if the number of individuals whose personal information you have is pretty low. So again, nuances. I think two of those states, Colorado and California, have gone through very comprehensive rulemaking activities, and a lot of the meat is in those regulations, right? So think about it this way: the statute kind of sets the skeleton framework, and then the regulations really put meat on that bone and really have the specificity that companies need to be thinking about. Looking forward, I think we're likely to see more in 2024. I expect a lot of states don't have the budget, don't have the expertise. They're just going to do more copycat type of bills, maybe with a few nuances. You might get a few states like a New York, like a Massachusetts, that wants to adopt their own framework. They're taking their time with that. And they're really, a lot of those states have multiple bills going on right now. So in those types of states, it may take a little bit longer. They may adopt something that's a little bit different, but I think a lot of states are really just going to continue to kind of follow those models. And then kind of last on that, I think from an implementation perspective and a compliance perspective, what most companies seem to be doing, what most of our clients seem to be doing, is really, at least for now, doing what we call the bucket approach. So you either live in a state that has privacy rights or you don't, but once you're in that bucket, with a few exceptions that maybe have a very significant business impact, but for the rest, we're pretty much treating everybody the same. So the consumers would have largely the same rights. We would provide largely the same disclosures. California has a slight variant of that sometimes. But by and large, we are trying to simplify operations to make it such that it's a one-size-fits-all approach. That can be challenging, and there are some situations where maybe exceptions are warranted, but that seems to be the most common approach. As these new laws, right? So right now we're at 5 states, if you count Utah. As the next 7 come into effect over the next few years, and as we add more, most likely, businesses really are going to have to determine if that bucket approach makes sense anymore, or do they just give the privacy rights to everybody? I think there'll be a tipping point at some point in time. Just every business can make that decision for themselves, but it's going to start to look funny if your privacy policy says that consumers in these 22 states have rights and their other states do not, right? So
Yeah.
you've had your test run, you've got to be able to accept and process these requests. And so kind of rolling that out to more consumers is what I see moving forward.
Gotcha. Looking at industry specific laws, what are you seeing happening there?
Yeah, so we just spent all that time and we're really talking about those comprehensive laws that really are intended to regulate a broad range of industries and companies. Beyond all of that, a lot of states are also looking at issue specific or industry specific laws. So the ones that come top of mind are the health data laws. So Washington, as many of you may know, passed their My Health, My Data Act. And then you have some similar legislation in Nevada and in Connecticut. It seems narrow, but it actually has a little bit more broad applicability than you think. So for example, in Washington, if any business collects precise geolocation data, they are potentially subject to that law. It talks about not businesses that use the precise geolocation data to, determine whether somebody visited a specific health facility or something like that, but if you could use it for those purposes, right? And so it's a very, very broad law. I think a lot of businesses aren't really aware of the fact that they could be swept up under that and need to be thinking about that. So that's just one example. Josh mentioned kids earlier. At the federal level, we're seeing that at the state level as well. So California passed what they call the Age Appropriate Design Act. Connecticut passed a similar amendment to its privacy law to add similar protections for children. The interesting thing here is typically the threshold age was either 16 or 13. So it was 13 under COPPA for online data collected from children at the federal level. It was 16 in a lot of these state privacy laws in terms of selling information, and that can include doing targeted advertising online and allowing third parties to collect data from your website. That's typically deemed selling in certain states or targeted advertising in other states. That's been the threshold. These laws, though, apply all the way up to anybody that's under 18. So there are a lot of businesses that may not collect information from children under 16 or certainly under 13, but do collect from 16 and 17-year-olds. And so that is something to think about. The California law is under a preliminary injunction right now. There's a fight over its constitutionality, and a court granted a preliminary injunction. So we're still waiting to kind of see what happens with that. That's been appealed. Connecticut doesn't have those type of barriers in place right now. So Connecticut law is scheduled to move forward. I think, Josh, correct me if I'm wrong, is that October of next year, I believe?
Yeah, what's interesting about the Connecticut one is it actually has several different effective dates. Some provisions are already in effect. Some provisions come into effect in July. Those are mostly around social media. And then the bulk of it for the types of clients we work with come into effect in October of next year. So it does have, Connecticut's got sort of this weird staged effectiveness.
Yeah. So bottom line, we are seeing that the concept of really trying to protect children, their data, their use of mobile applications, their use of websites, et cetera. We're seeing that at the state level as well. The last thing I just want to mention, Josh had talked about data brokers earlier and the FICRA amendments and kind of what impact that would have. We are also seeing data brokers being regulated at the state level. So we had already had states like California, Vermont, I think Nevada had laws already in place. This year we added Texas and Oregon. And so that's things like registering as a data broker, certain requirements around that. And then California passed its Delete Act. And so essentially at the highest level, the biggest impact of that is that you can make a deletion request, not to each individual data broker, but to California to distribute to all of the registered data brokers. And so that is something that those in that industry or those that rely upon data brokers are going to be impacted by. There's a lot going on. That's just the tip of the iceberg, quite frankly. In terms of having a 1-hour webinar, we don't really have time to get into the rest, but a lot going on.
A lot going on. And it seems like businesses, one thing that really stood out too is just the applicability. And there are a lot of businesses that could be getting swept up in, for example, the Washington health data law, that assume because of what they're collecting and how they're collecting it, they are not covered when in fact they are. So it's really important to make sure that you are getting ahead of those.
Yep.
Yeah, and actually, Lauren, on that front, you know, talking about the data broker, and then I'm going to go back to the health law, but the definition of a data broker is pretty consistent across all of these laws. But it's really important if you transact in data to go through the analysis of whether you need to register as a data broker, because the penalties under some of these data broker laws are quite high for failure to register. They can be upwards of over $100 to $500 a day. And so you can imagine how that would add up very quickly. And we've had clients who Vermont has sent a bill to and said, hey, we saw you registered as a data broker in California. You're not registered as a data broker here. Here's your bill for $50 a day. And so we've had that happen. The thing with the health data laws also that is really fascinating is a lot of the comprehensive state privacy laws have size thresholds that you have to meet before they're triggered. So whether that's like in California, there are 3 different ways to trigger CCPA. One of them is if you have more than 25 million a year in revenue. Then another way has to do with collecting the personal information of more than, you know, so many thousands of residents of the state. These health data laws don't seem to have those triggers. They do in the sense of how quickly you have to come into compliance. So larger entities are March, smaller entities are June. But you know, businesses that are maybe on the smaller end of the scale who have managed to dodge some of these comprehensive privacy laws because of their size may not be able to dodge these health data laws in the same way. And the other interesting piece has to do with geography. So we ran into a situation the other day with a client that's in Nevada. So their office is in Nevada. And they process personal information of people across the country. Some of that information is health information. And so their initial strategy was, well, we're just going to stop processing the health information of people who live in Nevada, Connecticut, and Washington. And then we don't have to worry about this. But as we were working on this with them, what the problem with that strategy is the way that both Nevada and Washington have written their laws in terms of applicability is it's not just if the consumer is in that state, but you can also trip it if the data is processed in that state. So the data could be of someone in Ohio, but because their office was in Nevada, now the Nevada health data law is going to apply to that Ohioan's health data. So some real trickiness there in the applicability analysis that businesses are really going to have to think through.
And one other thing that, and quite frankly, we might have buried the lead here. The Washington My Health, My Data Act has a private right of action, right? So we talk about these comprehensive laws, and they didn't have that private right of action. They're enforced generally by the state agencies, and there are a couple exceptions. But this Washington bill does provide private right of action with statutory damages. And so, you know, to the extent that there's any gray about the scope of it, you can bet that the plaintiff's bar is going to be aggressively pursuing that and arguing that it applies to all of these entities, right? So it is something that you really need to be thinking about. There may be some kind of desire to just kind of sweep it under the rug or put it on the back burner, think about it later. But I really do urge all of you that collect precise geolocation specifically to think about the potential impact of this law and the potential risks that private right of action poses.
Yeah, I feel like every question, every topic could be a webinar
Yeah, that's true.
in and of itself, but I want to keep us moving forward. We could talk about state laws all day long. Let's look a little bit more globally. Josh, I'm going to go back to you. So GDPR, for example, how is that influencing US privacy laws?
Yeah, well, as Nick mentioned, especially the Colorado-Virginia model borrows heavily from GDPR. If you look at the concept of consent, for example, the way it is defined in that framework is almost word for word the way it is defined under GDPR and the regulations that Colorado promulgated about how you collect the consent and the parameters around that are very similar to the guidance that the European Data Protection Board issued around collecting consent under GDPR. So we're seeing, the old joke is when it comes to privacy, Europe does it first and then it comes over to the US, 5 years later. And we're seeing that. We're seeing these legislators and regulators looking to Europe for inspiration and bringing that into the frameworks here. The other big news is finally we have a Privacy Shield replacement, the EU-US Data Privacy Framework. And so just to remind everyone, if you are transferring data outside of Europe to another country, under GDPR, that has to be done in a way that adequate safeguards are provided. And so one of those potential adequate safeguards is that the European Commission determines that the country it's going to has laws and regulations that provide adequate protection for that data. The US had worked out a system with the EU called Privacy Shield, where if businesses participated in that program, then the Commission would recognize them as having the adequate safeguards. A couple years ago, Privacy Shield was invalidated by the European Court of Justice in a case known as Schrems 2. And if anybody wants to hear more about that, I'm sure we've got blogs and webinars sitting on our website that can give you the details. And so after that, we saw the Biden administration and the Commission working on developing a replacement program. And that replacement program has been artfully named the EU-US Data Privacy Framework. And that is now in place. Businesses can register for it. There are certain rules you have to follow, certain disclosures that you have to provide, fees you have to pay, and whatnot. But we're encouraging clients who transfer data to the US to participate in that framework because it's an easier and more straightforward way to meet that adequacy threshold. However, there is still some risk. And you heard me mention Schrems 2. It's named after this guy named Max Schrems. And he's an advocate for privacy rights in Europe. He has already indicated that he and his nonprofit intend to challenge the data privacy framework on some of the same grounds that they challenged Privacy Shield, which have to do with US national security legislation. And so ultimately, it could be invalidated by the European Court of Justice. It'll probably take years before it ever, gets to that point through litigation. But that is a risk that it potentially could be invalidated. In the meantime, though, it's a tool, and it's a good tool to have in your toolbox.
I want to go back to what you said about consent a minute ago, Josh, and how some of these states are looking at GDPR's definition. They've incorporated it almost word for word. To your point, the Colorado regulations flush that out. I think a lot of companies don't fully understand what that means, right? So in their mind, getting somebody to agree to a privacy policy is consent for some type of data use. That's not how it works. It needs to be much more specific than that. Especially for certain types of uses that require consent in the US, right? We don't need consent for everything necessarily. It's not as much of a necessity here as it is in Europe. But when you do need it, there are very specific requirements. So I just encourage all of those. I think the Colorado regulations do a really good job of kind of breaking that out, what's required to get consent. We could certainly go back and look at some GDPR guidance and enforcement as another guidance point, but really think about consent and more than just having somebody agree to the privacy policy.
Yeah, and part of that is the consent has to be freely revocable, which I know is a source of heartburn for a lot of clients. That someone can give the consent and then take it away, and how do they deal with that? We also just got 2 questions in the chat that I know we were going to do questions at the end, but they're both really specific to what I was just talking about. So I think it'd be best if I just took them right now.
That would be great. I don't have my glasses, so I can't read them very well. Go for it.
So the first question is, if sending data from the UK to the US, does the data privacy framework apply? And the answer to that is yes. So the way that the data privacy framework, you have to check some additional boxes when you register, but the UK has what they call the UK extension to the framework. And then Switzerland has also agreed to the framework, and there's a box to check for them. So as long as you check all the boxes, you can register for all three. And the other one is, are standard contractual clauses or the binding corporate rules a fallback if the data privacy framework is invalidated? And I think the answer to that is still yes. The standard contractual clauses and the binding corporate rules are the other two mechanisms that GDPR recognizes for implementing those adequate safeguards. The one issue is that even when using particularly the standard contractual clauses, you still have to do an assessment of whether the country that the information is going to has laws that would essentially override the protections that those clauses are meant to provide. And if they do, then the clauses aren't enough. And there's a whole set of guidance out there from the EDPB, the European Data Protection Board, that they issued after the Schrems II decision, getting into this issue. So yeah, there's still a fallback, but there are definite considerations you have to keep in mind.
Great. And keep the questions coming. I'd love if we can get them in, while we're talking about the topic. Great. Otherwise, we'll excuse me, we'll get to them at the end. So GDPR obviously is the driving force, but other countries have privacy laws too.
Yeah.
Who else should we be paying attention to?
Yeah, I mean, dozens of countries now have privacy laws, and I'm not going to sit here and say I'm the expert in every one of them, because there are just a ton of them, right, to keep track of. But pretty much all of your major economic powers, Japan, Brazil, Canada, China, India, as of 2 months ago, have comprehensive privacy frameworks, and they all have their own nuances. They all have their differences that you need to think about. Even some smaller countries like the Cayman Islands, right? Tiny little country, has a comprehensive privacy law. And so anytime you're working with consumers or processing personal data of individuals who are located in these other countries, you need to be thinking about whether their laws are going to apply. And, one of the ones, just take our neighbor to the north, in Canada, Quebec has a provincial privacy law that they've recently made some amendments to, in addition to the federal PIPEDA in Canada. And there is a bill that has been pending in Parliament for a while now. Maybe it'll make its way through sometime soon, but it would update PIPEDA to be more restrictive, more GDPR-like, and we would see an even tighter privacy regime in Canada. So it is an evolving privacy landscape out there, not just in the US, but globally, and businesses have to stay in front of that.
Yeah, and that Quebec law that you mentioned, there are some pretty onerous provisions in that. So for companies that are collecting information from data subjects in Quebec, you should really be thinking about that, not just the federal Canadian law, as Josh mentioned, but that specific province law as well.
Mm-hmm.
So, excuse me. So before we step off of global discussion, we did have another question come in at registration that I'm going to toss to you, Josh. This is regarding the Digital Services Act. And hopefully the person who sent in the question is on the webinar now. How should businesses work in compliance with this act and incorporate it into their privacy programs?
Yeah, so the Digital Services Act is a piece of legislation out of the European Union that was intended to set a union-wide framework for how what are sometimes referred to as online intermediate providers operate. And so that category of businesses is things like internet service providers, domain name registrars, app stores, social media companies, online marketplaces, these cloud hosting companies, right? The companies that kind of provide the backbone of the internet and e-commerce and the way that people connect with each other online. And so this piece of legislation is intended to set a very detailed framework for those businesses commercially and with regard to privacy. It does not override GDPR. It's meant to complement GDPR and provide some specific rules for those types of businesses. It's very complicated. And so we don't really have time to get into it a lot here. And it's also very nuanced based on exactly where you sit. So like hosting providers have different rules than ISPs, who have different rules than social media companies. So it's very nuanced in its analysis and its application.
Okay. I don't even know how to add on to that. The complexities, you know, the more you talk about this, the more we just realize just the connectivity and the overlapping and always changing, changing. So no wonder you guys are so busy. Let's talk a little bit about enforcement, because here we're all about proactive compliance. Let's talk a little bit about the enforcement side of the house and what are we seeing with respect to enforcement activity, priorities, and so forth. Nick, I'm going to toss that to you.
Yeah, so I mentioned earlier that these comprehensive state privacy laws that most people are focusing on, and understandably so, they generally don't have a private right of action. The one main exception to that is that California law provides a private right of action for breaches that involve very specific types of information. So not just like name and address, but things that are a little bit more sensitive, credit card numbers, socials, driver's licenses, et cetera. So that's kind of one exception. But generally speaking, you know, somebody can't just say, well, I looked at your privacy policy, it doesn't comply, I'm going to sue you and I want my statutory damages. So that is one good thing for now. In terms of enforcement, California is the one that has been out the longest. We're seeing the most activity in California, as you might expect. Over the last few years, the Attorney General had posted examples of their enforcement activities. They're anonymous, but they name the industry that I don't want to say defendant, it was more generally notices of noncompliance and then giving them an opportunity to fix. A lot of that happened while there was a mandatory right to cure period as well. And so it lists the industry of the company, it lists what issues they had and what they did to fix it or to resolve the issue. As many of you are probably aware, there was one company that didn't fix an issue related to accepting global privacy control signals. That was Sephora. They ended up getting a fine. That was the first, and I think this thus far the only public fine that has been levied under CCPA. So that's all available. It's a great resource. I think it gives you an idea of the types of things that you should be thinking about. This year, the AG separately announced that they were doing an enforcement sweep of employers. So California is unique in that its privacy law applies to data collected in a business-to-business context and also data collected from employees or independent contractors. And so they identified some large employers in California and sent notices to them and are doing some type of an investigation / sweep of that. The other one that's been public is the Privacy Protection Agency announced an inquiry into data collected by vehicles. So there are a few things that are out there in the public. There's a lot going on, I would imagine, behind the scenes that we're not necessarily privy to. But that gives you kind of a flavor. I think it's reasonable to assume that they're going to pursue companies where they get a lot of complaints and then also pursue issues, right? What's an issue that we really care about? And then who's doing engaged in the type of activities that cause us concern based on that issue. I think that's likely what we're to see. The other states I think are likely to come at some point, right? A lot of them just had laws go into effect. So I'll have to wait and see how they approach enforcement. A lot of them also do have that mandatory right to cure period, which California had, but then sunsetted. So I think in those states, maybe the risk is a little bit lower because you'll have a right to cure if it's a curable, violation. beyond all of that, what we're really seeing a lot of, and I think a lot of the folks attending this webinar probably have heard the headlines, maybe been subject to some of these types of claims, relates to taking old laws and applying them in new contexts. And so we see regulators argue that, well, your privacy policy was incomplete or inaccurate. That is a deceptive practice. That is a violation of the state consumer protection laws, or as Josh mentioned, the FTC has similar types of laws that it enforces. And therefore, you're liable for such and such damages. Plaintiffs bar also goes after those types of claims, right? That these consumer protection laws oftentimes do provide private rights of action. So if you have an inaccurate statement in your privacy policy, for example, you open yourself up to that type of claim. But even beyond all of that, I think really where we're seeing the most movement, and this has been a couple of years, right? This is not something that's just happened in the last few weeks or months, but is really the volume is starting to really increase, are these old claims under wiretapping laws, under Vehicle Privacy Protection Act, these old laws, decades-old laws, where they're saying you're doing something online, typically with your website, that we think violates these laws. With the wiretapping claims, the most common things that we've seen are chat boxes. So you're recording the chat transcript without disclosing that, without getting consent. We've seen it with respect to session replay or session recording technologies. So these are used for a variety of different reasons, but essentially they track movements around the website. They track more than just clicks, where you hovered, how long you hovered. They have heat maps, things like that. And also just basic data collected through tags and other types of pixels. So one of the more recent ones has been that just the simple GET request. When I ask for I send a message to the website server saying I would like this URL to be displayed. Third parties, Meta, others are collecting that data, and they're doing so before the user has a chance to view any type of privacy disclosure. It happens instantaneously when I go to the site, and they're saying that that is a wiretapping violation. Now, the courts have not sorted out all of these issues yet. There are some defenses. So it's not to say that these are all violations, but they're claims, and businesses are having a hard time in many instances getting them kicked out early in the early stages of litigation. So if you do operate a website, you need to be thinking about risk mitigation options. I think for the chat box, for the session replay, which happens after you get to the site, it's a little bit easier. We can put some things in place to get consent arguments. I think for those initial GET requests, it's a little bit more challenging. Very nuanced issue. I'm sure there's lots of questions around that. We probably don't have time to get into the weeds, but kind of is the idea is to help you issue spot. And if you have a website and you have these third-party integrations, you really need to be thinking about how to mitigate all of these different risks. And so, doing a quick audit of your website, thinking about ways that you can mitigate risk, and just doing that kind of assessment of what's the impact if we do this in terms of the business impacted, and what are the risks, and coming out with a solution that makes sense for you.
Got it. Anything to add to that, Josh?
I mean, I think this is the world we're living in, where, especially since the TCPA has been tightened, a lot of the same plaintiffs that we saw, the same plaintiffs attorneys that we saw bringing TCPA claims are the ones bringing these SIPA and VPPA claims. And I think we're going to have to continue watching for these creative solutions to the fact that they need to keep up a certain volume of business for their firm when TCPA claims have dried up some. And it's going to be an interesting few years as we watch them shift gears.
Yeah, and that'll evolve over time. Like I mentioned, the VPPA claims, they were throwing VPPA claims against pretty much every website operator that had a video on there, like a YouTube video embedded, right? And the intent of that law was really supposed to focus on videotape service providers is the name, but people that provide subscription-based type of services, or think of like the old Blockbusters back in the day, right? And the courts struggled a little bit early on with that. I think the case law has largely been favorable for a just general run-of-the-mill website operator, but they still are sticking to anybody that operates some type of subscription service. I saw a headline, I think today or yesterday, about the Philadelphia Inquirer and how, at least at the motion to dismiss stage, they were unable to get rid of a VPPA claim. Doesn't mean that they violated the law. Doesn't mean that they won't ultimately prevail, but they didn't get it kicked out initially, which leads to defense costs and things like that. So again, anybody with a video embedded on your website, I think you should at least be thinking about it to the extent that you have actual subscribers. I think that elevates the risk and based on the case law that we have seen thus far.
Yeah, and the other thing I would say is if you're in the healthcare space, your risk is even higher, right? And we have seen these SIPA type claims, although sometimes they're not brought under SIPA, they're brought under different frameworks, but it's a similar concept, brought against a lot of healthcare entities for their websites, and that seems to be an area that's gotten a lot of interest. So if you're involved in the healthcare space, your risk is definitely higher.
Definitely agree.
Good to know. All right, speaking of high risk, scary things, I just want to touch on data breaches, probably up there with every business's worst nightmare. And to your point about, plaintiffs, attorneys are getting very creative in how they are, it's a very lucrative area, how they are bringing suit. Hackers and nefarious folks are being very creative in how they are getting into data. And so what are some of the things that you're seeing in terms of the latest tactics that are being used for unauthorized access, and how can businesses shore up vulnerabilities? Josh.
Yeah. So I think the main takeaway over this year for us with clients who have experienced these issues has been that humans are the weak point. You can set up great security protocols, you can have the firewalls, you can have the virus scanners, you can have the logging systems, right? You can set up all the technical pieces, but if you've got a human who engages with that phishing email or who gets manipulated into giving up information that allows someone to get into a system, it's right. That's the hard part, is controlling that human element, because humans are fallible. It's not that the person intends to do anything nefarious, right? They just give up something. We see here at the firm, we now have a code name for them. We call them fake Helen emails, where we get these emails that come in that for whatever reason, they always pretend to be from our partner, Helen McMurray, asking people to go buy gift cards. And we trash them and we block them, but that's the kind of stuff, right, that you see. And the other area, and especially when there starts to be an economic downturn, you can also run into issues of employees actually doing the things that they shouldn't do, right? So people get desperate sometimes in economic downturns, or they get mad at their employer, and sometimes they take data or they intentionally compromise a system or compromise access to a system. And so having great training, having those redundancies, logging, monitoring those logs, really watching who's accessing, what they're accessing when, and controlling that access, that principle of need to know, right? Someone should only be able to get access to the minimum data they need in order to perform their job function. And that's a critical component. Even though it sounds so basic, it's a critical component to reducing that risk.
And so the question was focused on kind of the practices themselves, but it's a good reminder that these laws have very specific data security requirements. So, the new comprehensive state laws generally just have a very quick, you must take reasonable care and implement reasonable protocols to protect personal information, essentially. If you're a financial institution, Josh talked earlier about how the safeguards rule was recently amended. The New York Department of Financial Services recently amended its cybersecurity rules. And so those have been released, I think, in the last month or so. And then for all businesses, California's Privacy Protection Agency is going through a rulemaking right now to address some of the issues that they did not yet address in the first round of regulations. And at the top of that list is cybersecurity. So they will have very specific requirements in terms of cybersecurity. So, when you're thinking about it, obviously you need to have the minimum policies and procedures in place. You need to have minimum data protections in place. You need to make sure that you're checking all the boxes. But as Josh pointed out, all of that has to go with this concept of employee training and awareness and everything else.
Words to the wise. Words to the wise. We've got just a couple minutes. I want to just touch on share a couple questions that we received early on. If there's any late breaking questions here from the folks in attendance, feel free to share those now. Looking in specific sectors, we had a question here dealing with financial services, and the person wanted to know what steps are companies in financial services taking to comply with data privacy when SMS texting with clients. Who wants to take that?
So
Go ahead, Josh.
I mean, I guess what I would say is SMS texting is a vehicle of communication, right? So the principles of the financial privacy rules would apply in that context just like anywhere else. So, for example, preventing disclosure of information to someone who isn't the intended recipient, right? How do you protect against that when somebody's standing at your bank teller booth? Well, how do you protect against that if you're communicating via SMS, right? It's more about taking the principles and applying them in that context rather than any specific, like the GLBA safeguards rule doesn't have specific rules around SMS.
Yeah. I think there might also have been some basis there in like TCPA type of laws, right? So to the extent that you are engaged in SMS or texting in general, there are other laws, TCPA, state equivalents of that may apply depending on the type of communication it is. Marketing have different rules than non-marketing. And so, there is that medium-based consideration, but that's more of that's not really kind of rolling up to these financial privacy laws. It's more about these generally applicable laws that apply to financial institutions and other types of institutions as well.
And I see we've got a question asking about specifically about TCPA state laws, and are we going to talk about those in this webinar? As you can see, I mean, we've pretty much filled up our time just talking about these other privacy laws, but I will say that in just a couple of weeks, we're going to be having another webinar with Michelle Schuster and Helen McMurray, and also our litigation director, talking about this is an annual session that they do every year, their crystal ball, talking about next year, what's happened this year, next year, and that's going to focus a lot on TCPA and telemarketing. So stay tuned for information coming out on that, but there'll be a lot of information about those state laws in just a couple of weeks. Another question that came in asking for clarification on any distinctions for B2B businesses where statutes maybe don't apply.
Yeah, so I mentioned earlier that the California privacy law does apply to business data. So if I'm buying a list of prospective customers that are businesses, I'm just collecting it at trade shows, whatever, those individuals have privacy rights in California. So that's the big one. All of the other states thus far, to my knowledge, have exempted data collected in the B2B context. So really, I think California is your focus, and we'll have to continue to watch that as it evolves with these new state laws that come out. But and we didn't get to this too, right? Like there's a lot of the states exempt nonprofits, but there are others that do not, or partially exempt nonprofits. So the applicability issue in terms of what type of data and what type of companies are regulated does vary. There's exemptions from state to state. For example, if we're talking a lot about financial institutions, in some states, if you're regulated as a financial institution under Gramm-Leach-Bliley or similar privacy laws, you're wholly exempt. Like the law just does not apply to you. Call that an entity-based exemption. California is a data-based exemption. It only regulates the data that is governed by GLBA. And so financial institutions may have other data collected through their website, buying prospective lists to market to, whatever it might be, that are not regulated by GLBA. And so that kind of database versus entity-based exemption is something that we see playing out. But the bottom line is it's really important for companies to understand what does apply and then come up with strategies for making sure that they're mitigating the risk associated with that.
Got it. All right, you two, you are a wealth of information. Truly, truly mean that. I want to thank everybody for attending. This is a quarterly series that we just started this year. I know we get a lot of the same folks on every single one. So feel free, let us know what you want to see covered as we go into 2024. If you want to do deep dives into, I know we talk a lot about getting people up to speed on the latest developments, but if there are deep dives that you find valuable, please let us know. Reminder that the recording of this will be available on the website in the next few days. If you're not already subscribed, if you're looking to stay up to date and make sure and to make sure that you are getting information on our upcoming webinars, you can subscribe on the website. That's mslawgroup.com/subscribe. And of course, Josh and Nick are available for any questions that you may have going forward. Josh can be reached at jstevens@mslawgroup.com. Nick is at Whisler, WHISLER, at mslawgroup.com. And with that, I just want to thank everyone for joining us today. I hope you found this helpful and enjoy the rest of your day.
Thanks all.
Thank you, gentlemen.
Thank you all.